A man walks into his kitchen and finds an eviction notice sitting on his counter, delivered while he was in jail, apparently by a friend who found it taped to his door. That's how Tyler Downing discovered his landlord was trying to remove him from his home. Now he's in court arguing the whole thing was improper, while the judge has to decide if someone put it on my counter is enough to stop an eviction.
That brings us to Grill Investments LLC versus Tyler Downing. This is case number 26448 LT. We're here for a couple different matters. We're here for our first hearing on a landlord-tenant matter and also a motion to quash the service. Mr. Thomas appears on behalf of the plaintiff and Mr. Downing appears on behalf of himself. Mr. Downing, do you remember receiving your advice or rights in this case?
Yes.
All right, bear with me. I do have to go through those with you. But you have the right to an attorney, the right, however, it's not something the court would appoint an attorney for, the right to proper venue and the right to a jury trial if you request that within a certain amount of time, the right to seek financial assistance and to know that a money judgment is not always necessary for that assistance, the right to resolve the case with mediation if both parties agree, the right to a consent judgment or a conditional dismissal, and any appeal to the circuit court must be taken within 10 days. And on the back of that, it talked about where you could get or at least reach out for financial assistance and legal assistance. I guess my first question to you today, looks like this is a straight eviction, but are you requesting any type of an adjournment for legal advice?
No, Your Honor, I just filed the motion.
So we'll get to that next. So you're waiving that. So your motion to quash, I've read that, and from what I understand, it looks like you had been incarcerated, you came back and you found someone's complaint on the kitchen counter?
It would have been, or I was incarcerated on the 12th and 13th, and over the weekend or whatever, it was Monday morning, I'm gonna say the 18th.
Had anybody been staying there with you or anything like that?
Same with me.
Yeah.
There, like one of my friends stays, he drives back and forth, his car's not reliable, so if it's bad, he'll stay there.
Do you know, did that person find service by attachment and put it in the house?
No.
All right.
Just left there on the counter.
So there has also been a proof of service filed in this matter, showing that service was made by first class mail and attachment on March 23rd. Did you receive that?
Yes,
Okay.
that was just a recent one.
Yes.
I guess it was taped to the door and one of my friends brought it in when they came.
Anything else you want to say about your motion?
I was never personally handed any documents or anything, and I was never directly to me. And then I feel like they've been tampered with my mail because I had just missed another court date for unpaid fines, which I never received anything in the mail. And now I don't get anything from front of the court. I don't get anything from this courthouse. So I just don't know if somebody's tampering with my mail or changed my address.
Okay. But you don't take any exception with the service that happened back on March 23rd?
That's the
Do you
one.
believe that's valid service?
It's hard to say, Your Honor, because I don't know who put that on my door.
Okay, but you received it
Yes, I received.
and you're here today.
Yes.
All right. Anything else you want me to know?
No.
In regards to the service?
It strictly says that it has to be mailed to me by first class mail directly to the.
So it has to be
roommate
served,
who I'm having conflict with.
well, it has to be served by first class mail. Who takes it out of the mailbox? We have no control over that. One of the things that it's either personal service and first class mail, or it's first class mail and attachment. And they're telling me the proof of service says that it was done by first class mail and by attachment to.
I never received any mail.
You never what?
I never received any mail.
Okay, but you did receive it by attachment, which is the taping to the door. Yeah.
Yes, but the law says that I have to receive a secondary copy to my room.
Well, do you know whether your roommate got it?
I don't know if he got it. I found the paper just
Okay.
laying there on the counter. I don't.
Was
know
it addressed to you?
I've never seen any. It was already opened.
Okay, but the summons, was that addressed to you?
Yes.
All right. Anything else?
Downing's confusion here is understandable, but legally misplaced. Michigan law allows substituted service taping documents to your door plus mailing them when personal hand delivery fails. The law doesn't require you to actually receive the mailed copy, only that the server sends it. Who opens your mailbox or moves papers around your kitchen isn't the court's problem.
No, Your Honor.
All right, Mr. Thomas, any response?
No, Your Honor, and I apologize for not filing a written response to this. At the time that we received the motion, even up till today, I've not received a return of the service to use to substantiate the allegations in a written response. If the court wanted me to, I would request time to file a written response if the court feels so necessary, but other than that, I had been waiting for the return of service to even answer the allegations.
Well, the court finds, I can't explain what happened, how your service appeared on your kitchen counter. I can tell you that I do have a proof of service in the file saying that on March 23rd at 10:11, you were served by first class mail and by attachment. Who opens your mail or gains access to your mail, that's outside of the realm of the process server. All they have to do is drop it in the mail with a first class postage addressed to you. If somebody else gets it out of your mailbox, that's not their issue.
Mr. Thomas.
And hold on, let me finish. And or attachment. So personal service, handing it in your hand. And if they're not able to do that, then attachment works as well. And you testified that it was tacked to your front door or taped to your front door. And that's by what the proof of service says as well. So as such, I find service is appropriate. So back to my original question then, do you wish for an adjournment for legal advice? Because he has asked that, I do have to grant him that. So we will grant a 1-week adjournment for legal advice. So we'll be back here next week on April 2nd at 2:15. Parties can go out to the front window where you checked in and get that next quote.
Thank you, Your Honor. Thank you, Your Honor.
The judge denied Downing's motion to quash, ruling that service by mail plus attachment to his door satisfied legal requirements regardless of how the papers ended up on his kitchen counter. However, the court granted a 1-week adjournment so Downing can seek legal advice before the eviction proceeding continues. The parties will return on April 2nd, 2026 at 2:15 p.m. Here's the hard truth about legal service. The system cares that proper procedure was followed, not that you personally understood what happened. Once papers are mailed and taped to your door, the clock starts, whether you found them on your counter in your mailbox or never saw them at all. Showing up to challenge it is your right. Proving improper service requires more than mystery about who moved the papers. Subscribe for more real courtroom moments that show you how the law actually works.